Good evening, everybody. Welcome to Courtroom Insider. Today is Wednesday, September 17th, 2025. Hope you are having a good week. I am back from Boise. If you watched last night, I was in Boise. I went through a 3-hour tour of the men's prison in Kuna, which is right outside of Boise. The IDOC did a media day. There was a lot of stories that came out after Brian Kohlberger was booked about the condition of the prisons and how they're so horrible and this and that. And we got to go through and see the prison facility. And I got to tell you, I was impressed. I'll probably be doing a Courtroom Insider on it maybe next week, because it was kind of an eye-opening thing for me. Like, they have a wood shop in the prison where the inmates, if they qualify, can go in and make incredible wood furniture. They actually redid their floor. It was a beautiful wood floor. We saw where they make the license plates for the state of Idaho. We saw other things in the prison, and we saw, the minimum security all the way up to the closed visitation unit. So anyway, that's where I was yesterday in Boise. Back in Idaho Falls today, or this morning, I went and spoke with a really fun group called the Professional Bail Agents of Idaho. And it's bail bondsmen and women from across the state who get together for these meetings once a year. And I had no idea that such an association existed, but they asked me to speak kind of a behind the scenes of the Daybell case. And it was fascinating to hear their side of things, especially the fact that Chad Daybell had contacted so many of them trying to get bail money and trying to get the money to work out so that he could bail Lori out, up to and including a day or two before he was booked. Before those children were found, he was still trying for months and months and months to get out of jail and to get her out of jail. And clearly that didn't work. So thanks to the Bail Association for having me. Tonight, I want to talk about the assassination of Charlie Kirk, specifically the legal angle and the charges that the suspect, Tyler Robinson, faces, and the court documents that have come out. Now, I have not really touched on this here on Courtroom Insider, mainly because I haven't had the time and I've been focused on other things and have been traveling a bit, not out of purposeful avoidance, but it's a case that is now the biggest true crime case in America, perhaps the world. And we learned yesterday from the prosecutor down in Utah County, which is where Provo is, that they are going after the death penalty and that court documents have been filed. Here is a little bit of what the prosecutor said at a news conference yesterday.
The murder of Charlie Kirk is an American tragedy. Charlie Kirk was murdered while engaging in one of our most sacred and cherished American rights, the bedrock of our democratic republic, the free exchange of ideas in a search for truth, understanding, and a more perfect union. It is also an offense against the state and to the peace and enjoyment of the people of Utah and of all those who visit here. But Charlie Kirk's murder also strikes a more personal and intimate chord. Charlie Kirk was first and foremost a husband and a father to two beautiful young children. He was a son, he was a brother, and a friend. Like all murders, the senseless and needless taking of Charlie Kirk's life has shattered the lives of those he loved and those who loved him. To Charlie's wife, Erica, his two young children, his parents, his family, and his friends, I express my sincere condolences and offer my heartfelt prayers on your behalf. I also want to express my concern for everyone who was at Charlie's Turning Point USA event at the Utah Valley University, and all who have been impacted by this tragedy. As county attorney, I am charged with bringing justice to those who offend our laws. I am charged with bringing justice for those who are harmed. I am charged with bringing justice for Charlie Kirk. I am committed to these aims. I take this responsibility seriously.
Now, after that news conference, a 10-page charging document was filed against against Tyler Robinson in connection to the murder of Charlie Kirk. This happened 1 week ago, if you can believe it. Charlie Kirk was speaking on the campus of Utah Valley University when he was shot and killed in front of thousands of people. The shooter went on the run, according to law enforcement, and he was apprehended a few days later after his parents figured out, and I'll read into the documents in a minute, figured out that it was their son. There is a lot of misinformation out there. There's a lot of rumors. There's a lot of speculation. There's a lot of nonsense. There's some stuff that you might think, that's true. There's a good point. Tonight, I'm simply relying on the facts of what is in the court documents, the facts that we know today. I'm not going to debunk conspiracy theories because mainly I don't have enough time or enough knowledge to debunk them. So this is hopefully just kind of a base as far as what's in the court documents and where we go from here. And in just a moment, I'm going to have Rachel Smith come on here. She's the special prosecutor from the Daybell case who has done hundreds of other cases throughout her career, death penalty cases, dozens of them, murder cases. She would be the type of prosecutor that could take a case just like this one. We're going to get her insight to hopefully help us understand what happens from here. But I want to read through the charging document against Tyler James Robinson. The state of Utah, first of all, I won't read through the whole thing. He's charged with one count, a capital felony, meaning death penalty, sort of could qualify for death penalty if it's capital. One count of aggravated murder with a victim targeting enhancement, meaning the charge is enhanced because the Charlie Kirk was targeted because of his political views. You can add an enhancement, like if you're targeted because of your sexuality or your race or your religion or your political views, they can add an enhancement to the charge. And there was a violent offense also committed in the presence of a child, which is an aggravating factor. So they have two aggravators. One, he was charged with an aggravator because of it happened in front of a child, and two, because of his political views. He was charged with a second count of felony discharge of a firearm causing serious bodily injury. That's a first-degree felony. And there was an enhancement on that, again, because of his political views and because of the children. Also, obstruction of justice. Tyler Robinson, with intent to hinder, delay, or prevent the investigation, apprehensive prosecution, conviction, or punishment. He concealed or removed the firearm used to shoot Charlie Kirk, and the conduct that constitutes an offense would be a capital felony or first-degree felony. The fourth charge, another charge of obstruction of justice, so he has the two. The fifth charge was tampering with a witness. We'll get into that in a minute because he talked with his roommate and told the roommate to withhold information according to the documents or an item. 6, tampering with a witness, another charge, so 2 counts of tampering a witness. 7, violent offense committed in the presence of a child. So 7 charges is what he is facing. He remains in the Utah County Jail, no bond, no bail. And here is the probable cause statement. This is what the investigators put together to take before a judge to say, we have enough probable cause or we have enough evidence to charge this person with a crime, and the judge has to sign off on it. On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office. DNA consistent with Robinson was found on the rifle's trigger. After shooting Mr. Kirk, Robinson had the gun, discarded the clothing he wore when he fired the rifle, and told his lover/roommate to delete incriminating text messages and not to talk to police. Children were present at the time of the shooting. Turning Point USA organized a public outdoor event to be held at noon on September 10th at UVU. The event was the first in a series of similar events to be held at college campuses nationwide. Mr. Kirk is a well-known conservative activist famous for these types of events where he discusses various political issues and debates with audience members. His events and comments have garnered a significant number of supporters and drawn the ire of many who disagree with his political views. The event at UVU was announced far in advance and garnered significant publicity and interest. Consequently, several hundred people attended. Mr. Kirk was interacting with the crowd before the event officially got underway. Then, approximately at noon, Mr. Kirk seated himself under a portable canopy held behind a table and microphone. He began speaking to the crowd and fielding questions from attendees, a format Mr. Kirk commonly used at the events. Mr. Kirk allowed his questionnaires to approach a microphone positioned directly in front of them. Mr. Kirk's team members were very close to him on the right and the left, as well as some behind the canopy and others at various close locations near him. The large crowd surrounded Mr. Kirk on 3 slides. Temporary metal fencing separated attendees from Mr. Kirk by only a matter of feet. Directly above and behind Mr. Kirk was the UVU Hall of Flags, an indoor walkway spanning several hundred feet with floor-to-ceiling glass windows which overlooked the plaza where Mr. Kirk was seated. People were in the walkway at the time of the shooting. Approximately 15 minutes into the event, Mr. Kirk was answering a question about mass shootings by transgender individuals when a gunshot rang out. The bullet struck Mr. Kirk in the neck. He slumped to the ground almost immediately. The bullet's trajectory passed closely to several other individuals besides Mr. Kirk, including the questionnaire, who was standing directly in front of Mr. Kirk. Children were visible near Mr. Kirk's stage when he was shot. Mr. Kirk was rushed to a nearby hospital where he was declared deceased. The medical examiner's report is pending. That's a synopsis of the shooting according to the court documents. Now, the UVU surveillance investigation. Police began to search the area. A UVU police officer was watching the crowd from an elevated vantage point. As soon as he heard the shot, he began to scan the area for threats. Believing the shot came from a rifle because of the sound, he looked for potential sniper positions. He noted a roof area approximately 160 yards away from Mr. Kirk as a potential shooting position and rushed there to look for evidence. The suspected shooter position is adjacent to the open, publicly accessible walkway. To access the suspected location, a person must climb over a railing and then drop to a roof only slightly below. The UVU officer climbed over the railing and down onto the roof. He then walked to the suspected shooting position and confirmed a clear shooting corridor between the position and Mr. Kirk's seat. He also noted markings in the gravel rooftop consistent with a sniper having lain on a roof. Impressions of the gravel potentially left by the elbows, knees, and feet of a person in a prone shooting position. I'll pause there. I imagine he got photos of that, I would think, if the officer noted it, took pictures to show as evidence. We have not seen those if he did. Continuing on in the court documents. Police reviewed surveillance film footage from the camera covering the roof and discovered that it recorded an individual dressed in dark clothing cross the railing from the public walkway and drop onto the roof at approximately 12:15. Although the individual moved out of the camera's view for a short time, the camera again captured the individual running across the roof and then low crawling to the area the UVU officer recognized as where the suspected sniper had dropped into a prone shooting position. After a short time, which matches the known time of the shot, the individual arose and ran across the roof to the northeast. The discovery led to an intensive review of UVU surveillance recordings to attempt to track and identify the suspect. Surveillance revealed the following. At approximately 11:51, the suspect entered the campus from the north. He is seen wearing a black shirt with an American flag in its center, a dark baseball cap, and large sunglasses. Throughout the surveillance, the suspect keeps his head down and rarely raises his head enough to get a clear image of his face. As he proceeds across the campus, he is seen walking with an unusual gait. The suspect walks with very little bending of his right knee, consistent with a rifle being hidden in his pants. This unusual gait continues until the suspect is seen crossing the railing off the open walkway and onto the roof, where he leaves the camera's view. A camera later captures the suspect as he runs across the roof to the suspected shooting position. Immediately after the shot was fired, a camera captures the suspect running across the roof carrying an item whose shape is consistent with a rifle. The suspect is then seen climbing down from the roof. He appears to drop the item he was carrying as he hits the ground in a controlled fall. He then picks up the item and runs toward the northeast end of the campus. Now, expanded crime scene investigation. Law enforcement officers followed the suspect's escape path to the northeast end of campus, where they believed the suspect left campus and entered a wooded area. In that wooded area, investigators found a bolt-action rifle wrapped in a towel. The rifle contained one spent round and three unspent rounds. This is consistent with the facts officers observed at the time of and immediately after the shooting. No shell casings were found on the roof, suggesting a bolt-action rifle rather than an auto-loading weapon, and only a single round was fired. Each round in the rifle contained an etched inscription as follows. The first cartridge, no Tice's bulge, OWO, what's this? Second cartridge, hey fascist, catch, arrow symbols. Third cartridge, oh Bella Chow, Bella Chow, Bella Chow, Chow Chow. Fourth cartridge, if you read this, you are gay, LMAO. The rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, two of the three unfired cartridges, and the towel. That is pretty strong stuff there. Law enforcement was unable to immediately locate the shooter, so they published photos of the shooter from the UVU surveillance cameras. Meanwhile, law enforcement continued to try to identify them. Now we go to the Washington County investigation. This is where, personally, it gets really interesting to me. On the evening of September 11th, as law enforcement continued their investigation, Tyler James Robinson went to the Washington County Sheriff's Office with his parents and a family friend to turn himself in. Robinson's mother stated the following to police. On September 11th, the day after the shooting, Robinson's mother saw a photo of the shooter in the news and thought the shooter looked like her son. Robinson's mother called her son and asked him where he was. He said he was at home sick and that he had also been at home sick on September 10th. Robinson's mother expressed concern to her husband that the suspected shooter looked like Robinson. Robinson's father agreed. The mother explained that over the last year or so, Robinson had become more political and started to lean more to the left, becoming more pro-gay and trans-right oriented. She stated that Robinson began to date his roommate, a biological male who was transitioning genders. This resulted in several discussions with family members, but especially between Robinson and his father, who have very different political views. In one conversation before the shooting, Robinson mentioned that Charlie Kirk would be holding an event at UVU, which Robinson said, quote, was a stupid venue for the event. Robinson accused Kirk of spreading hate. Robinson's father reported that when his wife showed him the surveillance image of the suspected shooter in the news, he agreed that it looked like their son. He also believed that the rifle that police suspected the shooter used matched a rifle that was given to his son as a gift. As a result, Robinson's father contacted his son and asked him to send a photo of the rifle. Robinson did not respond. However, Robinson's father spoke on the phone with Robinson. Robinson implied that he planned to take his own life. Robinson's parents were able to convince him to meet at their home. As they discussed the situation, Robinson implied that he was the shooter and stated that he couldn't go to jail and just wanted to end it. When asked why he did it, Robinson explained that there is too much evil, and the guy, Charlie Kirk, spreads too much hate. They talked about Robinson turning himself in and convinced Robinson to speak with a family friend who was a retired deputy sheriff. At Robinson's father's request, the family friend met with Robinson and his parents and convinced Robinson to turn himself in. The family friend spoke to police and reported telling Robinson that it would be the best if he brought all evidence with him to the sheriff's office to avoid police having to search his parents' home. The family friend also asked Robinson if he had any clothes that were related to what he did. Robinson replied that he had disposed of the clothes in a different area. Okay, so let me just pause there. If you're just tuning in, this is coming from the court arresting documents for Tyler Robinson, the man accused of killing Charlie Kirk. So we've got the explanation, the rundown of what happened at the scene of the shooting, what happened from the shooter's position, what happened with his parents. Now we're going to the roommate. Police interviewed Robinson's roommate, a biological male who was involved in a romantic relationship with Robinson. The roommate told police that the roommate received messages from Robinson about the shooting and provided those messages to police. On September 10th, the roommate received a text message from Robinson, which said, quote, "Drop what you are doing, look under my keyboard." The roommate looked under the keyboard and found a note that stated, quote, "I had the opportunity to take out Charlie Kirk and I'm going to take it." Police found a photograph of this note. The following text exchange then took place. After reading the note, the roommate replied, "What? You're joking, right?" Robinson, "I am still okay, my love, but I'm stuck in Orem for a little while longer. Shouldn't be long until I can come home, but I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. The roommate. You weren't the one who did it, right? Question marks. Robinson, I am. I'm sorry. Roommate, I thought they caught the person. Robinson, no. They grabbed some crazy old dude, then interrupted someone in similar clothing. Then interrogated someone in similar clothing. I had planned to grab my rifle down from my drop point shortly after, but most of the side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. Roommate, why? Robinson, why did I do it? Roommate, yeah. Robinson, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything about them finding it. Roommate, how long have you been planning this? Robinson, a little over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it. Robinson, I'm wishing I had circled back and grabbed it as soon as I got my vehicle. I'm worried that what my old man would do if I didn't bring back Grandpa's rifle. I don't know IDK if it had the serial number, but it wouldn't trace to me. I worry about prints I had to leave in a bush when I changed outfits. Didn't have the ability or time to bring it with. I might have to abandon it and hope they don't find the prints. How the F will I explain losing it to my old man? Only thing I left was the rifle wrapped in a towel. Remember how I was engraving bullets? The effing messages are mostly a big meme. If I see notices bulge UWU on Fox News, I am assuming, I might have a stroke. All right, I'm going to leave it. This really effing sucks. Judging from today, I'd say Grandpa's gun does just fine IDK. I think that was a $2,000 scope. Robinson, delete this exchange. My dad wants photos of the rifle. He says Grandpa wants to know who has what. The feds released a photo of the rifle, and it is very unique. He's calling me RN right now, not answering. Robinson, since Trump got into office, my dad has been a pretty diehard MAGA. Robinson, I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. Robinson, you are all I worry about, love. Roommate, I'm much more worried about you. Robinson, don't talk to the media, please. Don't take any interviews or make any comments. If any police ask you questions, ask for a lawyer and stay silent. Those are the text messages in the court documents. I know a lot of you have opinions about them. Are they true? Are they fake? Are they planted? Whatever. I'm just reading you what comes from the court documents that the prosecutor put into evidence. And when this goes to trial, the roommate, I imagine, will get called to testify about them. And they'll be able to geo-track those like they've done in all the other trials. Okay, the last section of the court docs. Police executed a search warrant on Robinson's residence. During the search, police discovered a shell casing with etchings like the etchings found on the shells in the rifle near UVU. Police also found several targets with bullet holes in Robinson's home. So it's like he had been practicing. Then it goes to the counts. Count 1, 2, 3, 4, 5, 6, 7. Based upon the evidence, we have reason to believe the defendant committed the offense as charged therein, signed by Jeffrey Gray from the Utah County Attorney's Office. So he then appeared in court. Here's a little video of him in court. He didn't say much. They're going to appoint him an attorney, and then the slow court process will begin. That is what came out of the charging documents. And there's more that we will probably learn in the coming days, weeks, months, and years. Now, to help us understand all this, put it together, let's go now to Rachel Smith, special prosecutor, who's very familiar with high-profile cases. Maybe not this high profile, but she's familiar with these high-profile murder cases. Okay, Rachel, so yesterday we had all of the information come out from the original charging document in Utah about Robinson. And were you a little surprised, because I was, that they went into so much detail as far as including the text messages? And why do you think the prosecutor did that?
Thanks, Nate. Thanks for having me. I think we're seeing a trend with prosecutors who begin to see the importance of community confidence in the criminal justice system for including a little bit more than they used to include. And so I was pleasantly surprised, but I think for prosecutors who pay attention to the community, we will see more of that.
Yeah. One of the things is the prosecutor is going after the death penalty in this case, and remind people that there has to be more proven as far as aggravating factors. What does aggravating factors mean, and what could some of those factors be in this particular case?
For a death penalty in any state, it has to be more than a murder. It has to be, and I put it sort of in sort of very basic terms of murder plus, and it has to be a designated issue that is defined in that state's statute called an aggravating circumstance. And that definition will vary from state to state, but it clearly in Utah, killing somebody because of what they believe, or killing somebody because of their political beliefs or their political speech is an aggravating circumstance. Targeting somebody because of what they believe. So it's an aggravating circumstance here is killing them because of what they said, what they espoused, what they did. Killing somebody because of what that person believes, represents, or manifests itself, or because your personal beliefs cause you to want to kill somebody for political speech, or in Utah, sexual orientation, religious beliefs, the color of their skin. Targeting somebody for a particular category of beliefs are aggravating circumstances that qualify that case for the death penalty. And it's clear the prosecutor has picked several of those categories as reasons why the death penalty is appropriate in this situation.
I think one of them too was the fact that this happened in front of children.
Yes, I did see that aggravating circumstance. And, I think, and risking multiple lives, that is one almost every state has, where if you use a device in a crowd, a shotgun, a gun in a crowd where you could hit others, often it's used if something's involving a bomb. So you're using a device in circumstances where multiple people can be hurt, or using a device designed to hurt multiple people. Those are aggravating circumstances. Those also were picked in this situation.
A lot of people look at this and say, oh, it's cut and dry. He had the text messages that he sent to his roommate. They have his DNA on the towel around the gun. They have the video. They have all this stuff. He told his dad. So what obstacles, what challenges lay ahead for the prosecutor?
I think one of the things I've learned over many years of being a prosecutor is there's no such thing as cut and dry. And in a case like this, there are many obstacles for those prosecutors, and it's very clear they're going to try to operate clearly within their rules, but as transparently as the rules allow. So that is an obstacle, is everybody around them in their community, most pointedly, where they're picking their jury, which is where they got to focus, forming an opinion about what they believe the evidence is or is not. And so controlling that information at this point, asking law enforcement to now begin to scale back what is public, because you begin to create an environment where it will become very difficult to get your jury. It'll become cost prohibitive to get your jury because you're going to have to move it across the state where somebody hopefully has never heard of it. So that's a huge challenge for them, is managing expectation, managing information flow, and controlling it so that no one on behalf of the government is creating an environment where somebody can't get a fair trial. So they are going to face those challenges. They also, I believe, will likely face fairly quickly a mental health, mental disease and defect defense, some sort of mental illness that would be a defense to these charges. Logically, that's where most death penalty cases go. Most death penalty cases are not cases where it's a question of who did it. It becomes a fight about why they did it. And human nature being what it is with jurors, they don't want to believe that people are just sometimes evil or malicious. they would like to believe that somebody is doing it because they have a mental illness. However, it's easily overcome. Once you show them one or two rational choices, a psych defense goes out of the window. But that's kind of a lot of information there. They're going to face issues with information flow. They're going to face issues managing expectations for their jury and their community pool. They're going to face issues where their work of law enforcement is going to be attacked, and they're going to get accused of poisoning the pool against the defendant such that he can't get a fair trial. They're going to begin to face issues related to the defendant's mental health.
Yeah, put on your defense cap if you can for a minute. Were you ever a defense attorney, Rachel?
I had 1 year in law school trying to be a prosecutor where I worked for a defense term. I was actually sworn in so I could second seat a homicide. So yeah,
well, you've been in a lot of cases with defense attorneys, I should say.
Yeah.
What could possibly be his defense? I mean, if you were assigned to be his attorney today and you walk in and he says, yeah, I did it, or I didn't like what he was saying. I mean, where do you go from there? You mentioned the mental illness might be one, but where do they go?
I would instantly I would approach the court for a gag order. In this particular case, as a defense attorney right now, when you have people in very prominent, high-profile positions commenting on the guilt or innocence of your client, I would try to tie that directly to the state actors involved, and I would try to get some sort of gag order with sanctions that would eliminate evidence, that would remove, a sanction can be, striking certain forms of evidence. So I would be seeking gag order or seeking some sort of restriction on government actors and asking for consequences for leaks as a defense attorney. I would then be instantly putting in all sorts of rules with the jail, like nobody gets to talk to my client without my permission. I would ask that his phone calls not be recorded. And then I would be quickly getting doctors and or psychologist and psychiatrist in there to begin evaluating him. The clearest path forward, at least as far as we know and what we've been given, is there's going to have to be some sort of diminished capacity defense and or some sort of effort to show he had some sort of mental illness that made it difficult for him to control himself.
I can't think of a more high-profile case, one, because this was such a high-profile crime that happened live in front of our eyes with multiple cameras rolling, and you saw it happen, and it was so horrific. Two, the suspense of who did it, and that led on for a few days until they found him. Three, that his parents, according to the police, turned him in. I mean, it has all of these elements of just unbelievable. And the fact that Charlie Kirk is so high profile and revered by so many people, that means there's so much misinformation. Yes. Already there are people doubting if these text messages are even real, if there were other actors helping Robinson do this. How, as a prosecutor, can you even get caught up in that? I mean, how do you deal with that? I imagine their phones and emails are just off the hook over the past few days of people with tips or helpful hints or whatever.
Well, and you're absolutely right. For the prosecutors in this case, they are going to have to just put their head down and focus on who was taken and who did it, and then assign following up on leads or rumors or media to other people that are not the lawyers or the paralegals on the team. It is a case like this, it is beyond important that the prosecutors really just focus on who was taken, who took them, and how and why that happened. Worrying about sort of all the other in the conspiracy theory, you lose focus. And the minute the prosecution team loses focus or gets distracted by the red herrings, the minute they make a mistake. So I was looking at the press conference that the prosecutor in Utah did, and he has a team behind him. It's clear just on his pleadings. He has multiple lawyers listed. So clearly he's pulling in the staff and resources. They'll divide the case up likely with people responsible for certain facets and reporting to the head prosecutor, which is the way it typically happens. Looks like he's already begun that structure, just looking at whose name's on the documents. And then delegating, for example, in the Vallow Daybell case, Rob Wood right away, within several months when it became clear that the media was sustained and long going, he brought into the team a media person whose job it was to pay attention to the media. And I don't mean like following the reporters. I mean, paying attention to the information being disseminated to the public, because you can't ignore it. That will mean your jury pool, but it doesn't have to be the lawyers. And so having a member of the team who's a member who's charged with looking at the media, paying attention to, okay, that's just crackpot. I don't need to bother the boss with that. Or, ooh, this one might have some legs, and taking it to the team and getting some analysis is an important factor that will help them kind of manage. I think if you look at it just from, this is a tragedy of a 31-year-old husband, father of two, who was shot and killed by a lone shooter, maybe with some accessories after the fact, maybe not. That fact pattern is bite-sized, manageable, and candidly, that's the core of what the jury's going to hear. And so if they focus on that and have a team around them to deal with the other things, then it's manageable.
Yeah. Yeah, as you've said before, that can be the story that is repeatedly the theme that is repeatedly told to the jurors. Now, he appeared in court. The judge set the next date for a few weeks from now, end of September, and then I imagine he might set a trial date, or at least the next hearing date. And we in the public might think, oh, okay, it's going to go to trial in January or March or whatever. Realistically, when do you think this could go to trial?
I think it's going to be driven by two or three different things. One, how quickly they can get a defense bar and a defense team up to speed and able to begin the process of reviewing the case and applying a review of mitigation. That typically takes 18 months, perhaps longer, for a defense attorney to get there, because they don't immediately get all the reports and then they've got to analyze them. But on the background, they will have members of their team. Some use investigators, some use what's called a mitigation specialist, which is analogous to a social worker or investigator, to begin to pull in social service records, family, etc. So the defense has their own investigation to do. The state will be ready when they need to be ready. It will be hard, but they will clearly, prosecutors get their case ready when the judge tells them to have it ready. But they're not done. I suspect just the FBI leads alone are still being sifted through, and that can be hundreds of thousands of pages. So
Right.
The investigation's not done. Law enforcement has a lot of work, but the defense has to review all of that and then do their own. So I think if we see a trial in sooner than 18 months, and I think I'm being generous, overly optimistic, actually. I think if there's a trial sooner than 18 months, I will be stunned.
Right. Yeah. It could be years away. And we
It
know
could.
that based on what we have seen in those court documents, he told his father, his parents were involved. They went to the police, according to the documents. His roommate was involved. I mean, potentially, if this goes to trial, these people could all be called as witnesses, right?
In order to prove the things that are listed in the supporting affidavit to the charges, they will have to call those people personally. Yes.
So we could hear from his mom, his dad, the roommate, all of those people, the minister, or the retired sheriff's official who he went and told, all those people. What about the thousands of people who were there that day and witnessed it? Obviously, you were not going to call them all, but do you need to call any of those people if you have the crime on tape? I mean, can you just show the video?
No, the only reason you would select a handful would be people who had direct image of either the shooter or trajectory or something that would contribute to put physical evidence or audio evidence in context. So I read some stories, I think it was like with Newsweek, where there was a person who was part of a team who figured out what they thought was the angle and the trajectory and got up onto the roof and saw the impressions and the prints. So if that information, to your point, if that information out there is accurate and that is a credible source, then that person who would be part of the crowd or security team will be called. You can't possibly, nor would you want to. There's actually rules that limit cumulative evidence. So you can have witnesses who talk about the same content, but they have to provide a unique perspective. And if the person there just repeats the exact same thing that somebody else has said, you can do that once or twice, but after a while, most judges will limit purely cumulative evidence. So most prosecutors really try to focus on people who can provide multiple facets of the overall story.
Yeah. And you think about, too, even hearkening back to the Daybell days where there were witnesses that we didn't even know about as the public who were called that provided some really interesting insight. And could be that if Robinson stopped by someone's house on the way to the university and asked for directions or something, I mean, there could be witnesses that today we don't even know about, maybe the prosecution doesn't know about, and that will come forward down the line and they could possibly testify.
Yeah, and I think that's a really good point that as investigations unfold, law enforcement, in this case, the local law enforcement partnered with the FBI, because it's in the end going to be a local law enforcement case. They will work on those elements that get the person in custody and that provide probable cause to hold the person. And then they'll go back and look at that sort of next deeper level and say, okay, we heard about a Ring camera down the street from his house where he left. And I made that up, so don't anybody quote me on that. But it's an example.
No, I think there actually was, Rachel, that TMZ got video of a doorbell camera of him walking by.
That's what, and so I don't want to.
Right.
I don't know the validity of any one of the things I've seen in
Sure.
media sources, but so I just wanted to throw that out there. Then you will go back and they'll say, that wasn't necessarily needed for probable cause. So they'll go back and they'll do the deeper dive. They'll get the original, they'll talk to the owner, they'll verify the times and make sure they are now in that transition from getting the person into custody and having enough to hold to the beyond a reasonable doubt gathering of dotting those I's, crossing those T's.
Right. Right. Well, is there anything else that you think the public should know as this case begins to unfold in front of us, kind of? I mean, now that he's in custody, things will probably be quiet for a little bit until he has these hearings. But what do you think would be helpful for us to know?
I think giving law enforcement some breathing room, now that we know the person is in custody, I think it's important for the public, despite their desire to know, to recognize that we have a system which is full of rights and freedoms that many, many people fought very hard to get us, right? And we need to respect that system and freedom and not hold it against the people who are working in the roles. These prosecutors need the ability to get their job done in a way where people aren't having undue or unfair expectations. The judge needs the ability to do his job, follow the rules, and make sure that whatever result comes out is based on fairness and not public vitriol.
Rachel, thank you very much
Sure.
for chatting with me. Always a pleasure talking with Rachel Smith. She's quite knowledgeable, and I appreciate her coming on to answer these questions. And I imagine many of you have questions about this case and others, and we'll try to stay on top of it here on Courtroom Insider. Have to thank newspapers.com, our sponsor here at Courtroom Insider. It's been fascinating to me going back and reading on newspapers.com about JFK's assassination. and what things were like then versus now, and how that time you can go through, you can see the pictures. I mean, I studied the JFK assassination in school. We all did. But newspapers.com has this incredible archive of newspapers from historical events. You can find your family members in there. You can find friends. You could do a Google search of yourself. I haven't found much of me in there, but for those of you that are more familiar with it, if you find anything with me, not Nate Eaton, the baseball player, but me, I'd love to see the articles. I did a search on me. I wasn't in the newspaper very much. I probably have a TV archive out there, but newspapers.com, they are sponsoring Courtroom Insider. Go to their website. You can get a 7-day free trial and check it out. And I know that you'll find a lot of interesting stuff. Want to thank you so much for watching tonight. Here's where you can find me. I'm on Facebook, Instagram, X, and YouTube. Subscribe to us if you haven't already. We appreciate your subscriptions. It's free. You don't have to pay us anything, but you can keep up to date when we begin posting these. And we have some exciting future episodes of Courtroom Insider coming up probably tomorrow night. Working on one right now. Should get it done. Yeah, so if not tomorrow, definitely next week we'll be back. We'll continue to follow these cases, and would love any suggestions that you have on things you want me to look into. Please send me a message and I'll look into it as best I can. Thanks for watching, everybody. Have a good night. We'll see you later.